Okay, we are back again this week. It seems like we're here every week. It's 7 o'clock Central Time on Wednesday. Um, Adam Cohen is joining me. I'm Greg Siskind. Welcome back to people who've been here before. If you haven't been here before, we use this live stream basically to cover our list of the major immigration stories of the week. It seems like, Adam, we could probably come up with a much longer list than the ones that we come up with as far as things that have happened. But we try and mix it up as far as subjects that we cover, populations that are being affected. And sometimes we take questions. We're not basically, this is not a sort of a call-in show where everybody can sort of get their immigration law problems resolved, but every once in a while we can, if we see a question that we think that would be of interest to the audience, we will take it. So if you are watching this on YouTube or X or Facebook or LinkedIn, if you make comments, we can see them, and that's where you would ask a question. So with that said, Adam, why don't we, when we get to the week stories, this is sort of a kind of a list that has TPS, I guess, is sort of like for the lead.
Well, it doesn't have to be, but it kind of fits into broad topics. Just varied topics for you all to be aware of. TPS, some consular issues. Actually, there's plenty of consular issues to discuss.
Yeah, well, TPS. So
courts.
there was news from the government on TPS, and then there's news from the courts. From the government, we had Nicaragua, Honduras, and also we had a Haiti. The Haiti has had more than one designation, so I guess this is another one of the designations that was added. But and then we had Nepal on August 5th, so that's still relatively recent news. And of course, we have Venezuela has also seen TPS revoked. And basically, what's been happening is the administration will announce a TPS termination, and then the things end up turning over to the courts at that point. There was a case for the sort of the initial case for TPS for Venezuela, and a judge issued a national injunction stopping the administration from proceeding with it. And just so people know, sort of like the legal basis for stopping TPS is even though presidents have a lot of authority to start a TPS program, there is a process that they have to go through to terminate TPS, and that includes demonstrating that the actual danger that was the basis for TPS in the first place, that the conditions in the country have changed and the basis for TPS is no longer applicable. It's a little bit easier, I think, for some countries than other countries. If there's, for example, there was a civil war in a country, and the war has ended, and it's stable, you might see that would be the end of TPS for a country. Or if there was a natural disaster and things have recovered, then you might see that end. But it is not by any means clear on any of the countries that have been announced that the administration has made any attempt at all to document that conditions are acceptable. So, you look at Afghanistan, for example, a country that's also on the list of the ones that have had TPS terminated. I don't think anybody thinks that that it's a safe country for for a lot of different populations that are here from Afghanistan. Haiti has more problems than ever, and sort of know that because there are travel warnings that the State Department puts out. Not just sort of like just be careful, but like you should not be traveling to these countries. It is absolutely not safe to be going there. Those kinds of warnings exist, and yet the administration is terminating TPS, essentially saying everything is fine in these countries for as far as sending people back to those countries, but the same agencies that are responsible for administering immigration are telling Americans absolutely do not go to these places. You're risking your life. And those are the kind of things that the lawyers in these cases are raising. So what happened in the Venezuela case was that the Supreme Court, without and this has been a common theme with and just happened again this week in a different case, but really without explanation, this was with the Department of Education being basically allowed to be dismantled this week. The Supreme Court greenlighted it without actually a written decision explaining the logic for it. And they did that on the Venezuela TPS case, where basically they said no national injunction. Now we got a decision, not too long ago on another case where the where national injunctions were really scaled back, and this was on the birthright citizenship case, which we've talked about before on this live stream. But in this case, they did say in the oral arguments in the birthright citizenship case that, and several of the justices said they would have looked at things differently had the case been brought as a class action. The interesting thing, and I think I talked about this last week, was or maybe 2 weeks ago, was that there was a warning from Justice Alito in a concurring opinion, sort of anticipating that was going to become the strategy, saying, hey, fellow conservatives, who just basically said, we have a problem with the with national injunctions, but not if you do them as class certifications, where there's a lot more process and you have to document a lot more things before a judge will agree to do anything. That this is going to, this is now the playbook that's going to be used. And Justice Alito was right, because that's exactly what has happened. Now I'm glad Justice Alito was right in this case, because I happen to think that these actions are justified by these judges. But we saw that, Adam, in another case this week, the birthright citizenship case, which was the subject of that order, right. A class was certified and a national injunction was issued. And I know that's one of the things on our list, so you can kind of like.
Right. We can check through that one. Yeah, but great. You got to the good news early.
Yeah. And I think every lawyer that has been with me on from our firm that's been with me on this, when we've discussed this, we've all sort of been like, nobody's gotten super nervous about the loss of birthright citizenship, because we all had assumed that it was going to be taken care of by the courts and this wasn't going to go forward. And then we got this Supreme Court case. And even then we sort of, let's just take see what happens. They have 30 days the order was allowed to, the Supreme Court gave the court 30 days basically. And the plaintiffs 30 days to figure it out. And they did, they moved very quickly through class certification. What we were worried about was that we were going to have to file tens of thousands of suits across the country on an individual basis. Basically, as soon as you got your baby's birth certificate, you're going to have to run to court, file a lawsuit to claim birthright citizenship for your child on there, which was, something that I think the Department of Justice, it would have been sort of just desserts for them that were, when they were arguing to try and do this, that they would have to, and saying that the proper, people should properly have to file these cases one at a time on there to make them defend it one at a time, which would have collapsed the Department of Justice under the weight of their own policy. So that had happened, but we are waiting to see what's going to happen on the TPS cases with respect to this. So in the Venezuela case, they are trying to convert to a class action in that case, and the judge may give basically issue a national injunction the same way the court is doing in the birthright citizenship. Which, by the way, that was the New Hampshire case. I think was the one. There were 4 cases for birthright citizenship that each one of them issued a national injunction. Those were all wiped out, but this is the first one of those 4 that actually certified class and issued a new national injunction. So that was news this week. It didn't get a lot of attention from the media. There's plenty of things to focus the media on, but I know for a very broad group of people that listen to this live stream, that was something that they care about. I care about it just as an American, but so that was some good news this week. But anyway, back on TPS. So we have these TPS revocations, and we will, I believe, every time they've done one of these TPS revocations, there has been a lawsuit that has been filed for that particular TPS designation. We are also at Adam and I our law firm is part of Impact Litigation, and we file national suits. We have been onboarding quietly a Venezuela case, and we're kind of waiting on what happens with the court that is looking at the national injunction and converting that case over to class action. And we will, if it looks like they're either not going to do a national injunction or it's going to be limited to, let's just say, the federal court district or the circuit, the circuit court region, then we will, start publicizing that case, because people are going to have to probably sue in mass actions to be able to get relief if that actually happens. So keep an eye on that if you're in one of these TPS categories.
Right.
Adam, you want to switch over to more litigation stuff and stuff that we're working on and talk a little bit about the student case?
I guess before we do that, let's I just had a couple more things to add about TPS, and I hope Greg, we haven't just announced the sole good news of everything that happened this week just with the birthright case, but there's just a lot of things that we're paying attention to. And I will say that as these categories are ending, there is some type of transition period that they're putting into place. Greg was mentioning August 5th for Nepal. Keep your eye on that. A lot of these designations, they do have some type of transition period.
Nepal could be a hard one just because it was based on an earthquake, and I don't claim any expertise on Nepal on there, but that's one that it's not a big population in the U.S., and I'm not sure sort of if they're organized and if they're going to be doing anything about it. I'm not. I honestly have no idea sort of how many people were actually in the U.S. A lot of them may have left. A lot of them may have found other means to stay, and whether they are and what the current conditions are in Nepal would all affect whether that's going to actually be successfully litigated. They're not all exactly the same, but they all sort of have the same issue, which is they have to show that the conditions haven't really markedly improved.
Right. And I think that, we're just going to continue to see as the year rolls on and we roll into next year as well, that a lot of these categories, I don't know what your thoughts are on it, Greg, but, that a lot of these categories are going to start to melt away, at least that the administration is going to try to end them. And we'll see what happens with litigation efforts. Would you expect the same?
Yeah. I mean, we're losing some of the in some respects. Well, in some respects, we're losing some of our options with the Supreme Court decision on national injunctions. Mm-hmm. There is one positive in that regard that is also not in the news this week, and I think we've mentioned it before. But there will be some really good news coming on DACA soon because of that Supreme Court decision, and basically DACA, in 2018, the administration there was litigation in 2018 by governors who filed a case in the district court in Texas, and the district court sided with the Republican governors and said that the DACA program was illegal, and then issued a national injunction on new people being added to the DACA program. It also enjoined advanced paroles for people in the DACA program. And essentially, it just sort of like froze for people. That population that was already in DACA could stay in it and continue to renew and continue to get work authorization, but nobody else. Like, there were a lot of people that were young people that were too young to apply for DACA, even though they would otherwise have qualified, and they were just waiting to graduate high school and were going to be able to apply for DACA after that. And there were all, I don't know how many hundreds of thousands of those people were there. There were a lot of people who had DACA applications filed as well that never got them adjudicated. They were just basically frozen after that order. And the what happened was the Fifth Circuit looked at the recent Supreme Court decision, and they said to Judge Hannon, the district court judge, you can't do a national injunction anymore. And basically what is about to happen is that Texas is not, if you live in Texas, you are going, the Judge Hannon's order is going to be limited to just the state of Texas, which means, it could be very bad news for Texas, because I think he could take it to the logical step in saying basically nobody in Texas, if you reside in Texas, there's no more DACA renewals or anything like that. So it's effectively going to force people to leave Texas. But the other 49 states, it looks like the USCIS is going to have to reopen the DACA program to everybody. The Trump administration could try to oppose, but DACA is pretty popular. And I am not so, and the administration has said in the past that they wanted to figure out a solution for DACA. So I'm not so sure that they're going to they're going to oppose it, but I think we'll probably see litigation fairly soon to force Judge Hannon to revise his order based on the Fifth Circuit directing him to, and that it hasn't happened yet. So look for some big news on. I am expecting a lot of people who have been undocumented for a long time to suddenly become eligible to apply for DACA, probably in the next 30 to 60 days. I guess.
And that's sort of the direct result of this limitation of national injunctions by the Supreme Court, right? So so
it's kind of like,
yeah.
And this is the thing, about it, that it's sort of like, I'm of mixed feelings with the Supreme Court on this. I get it on there. It had basically been a very effective way that, these district court judges being able to quickly issue a national injunction to put the kibosh on a Democrat or a Republican president trying to do things. And Congress has basically not done anything on immigration in decades. So the executive branch is largely left to deal with big national problems. And that has been that has made it really difficult. The injunctions in the Biden administration, we saw that over and over again. In the Obama administration, the DAPA program that was many years ago, we saw a lot of this happening. And in the Trump administration, the first one, honestly, we litigated a lot of these things, and it was very effective as far as litigation to stop Trump policies. Thank goodness. But it is not necessarily the best as far as like where, an individual judge could do that. It's very much depends on where you're sitting and what the individual judge is doing. So I get why the Supreme Court did it. On the other hand, judges do need to have some authority to, stop clearly unconstitutional measures. It's not a question of sort of like, like really overreaching on, something that is a stretch of the statute or something like that. But birthright citizenship, that should have been an easy national injunction for a judge saying this is clearly unconstitutional on there. So that's that's on the national injunctions, that would be sort of like the positive that you might see, where some of the things that were stopped might start again. But in general, class actions sound like probably where everything is basically just going to be done in via class actions. That's not so easy for the governors, that file these suits and do it that way. So they're going to have to do a lot more work. As far as national injunctions go, but I do think a lot of class actions, I think probably we'll see as judges maybe fast tracking class certifications where necessary.
Right.
So, all right, Adam, what do we got next?
So just one last thing I'll say, just on the TPS side, right? Because of these sort of categories that are shifting away, just important to think about, changes of status to get out of TPS, and understanding that through the regulations, there is a way to do this. There are some requests for evidence and things. We're starting to see some of these trends where people have traveled and maybe they re-entered on a non-immigrant status that lapsed. And there gets to be some things when you add in international travel, or where somebody had a period of time where they were not in a non-immigrant status and not in TPS, where it makes that change of status more difficult. But it is something to think about in terms of moving to another status. I don't want to leave behind the litigation too much, though, Greg. I wanted to talk, let's talk about our lawsuit, just sort of this, I was going to say sort of the corollary or the next step, I guess, in the SEVIS related litigation. Did you want to cue that up at all?
Yeah, I want you to maybe just give a quick history of the case.
Sure.
Like what prompted our initial case,
right.
And then what what happened with that case, and what's about to happen with our litigation strategy.
So when we started this litigation, it was the result of, basically this coordinated Department of State, Department of Homeland Security efforts to flag and deactivate SEVIS records for students who had any type, and to revoke their student visa as well, who had any type of encounter with law enforcement according to a specific type of criminal database, right? So it was this effort that was both removing the visa and essentially removing their lawful status within the U.S. as well, right? There was arguments that the government was trying to make that, a SEVIS record is not the same thing as having valid student status, but the SEVIS record is essentially this is a post 9/11 system, monitoring system, that as the student moves about as a student within the U.S., all of their actions, their transfers, reducing course load, working on optional practical training, all of these things have to be approved and noted in the SEVIS system. So if you deactivate the SEVIS system, you remove the status, right? And so the lawsuit, the first litigation that we had, and there was and that was part of impact litigation, as well as several other lawsuits from other firms across the country, was basically to stop this lawless, illegal, lack of due process situation where these SEVIS records and thereby the status was being deactivated, right? And so as this surge of litigation came, the government reversed course and they stopped this policy. They reactivated all of these SEVIS records that had been previously deactivated. And so these students, all several thousand of them that were affected, were
68,000.
How many? 68,000?
No, 6,000 to 8,000. That was
6,000 to 8,000. Thank you. That's right. was thinking that was a little high. So, that basically took care of their status while they are present in the U.S. However, it doesn't solve for this issue of what if they, when they inevitably travel to visit family and things of that sort, right? That part really hasn't been resolved. And that was something, Greg, I know we had that, sort of in our litigation initially, but it requires a separate lawsuit. We were successful, as many other firms were successful in this type of CVIS related litigation. But we took that success and we are filing a separate lawsuit on
yeah,
the visa.
Basically,
yeah,
we got everything that we requested with respect to Department of Homeland Security, and settled that side of things with the with DHS. As part of this, the government wanted the case dismissed with prejudice. Now that means basically the case is over and we can't bring the claims back again. And we said, well, no, because we're suing the Department of State also, and we need to deal with the visa revocations claim. So they agreed to allow us to amend the case to take out the Department of State. We did that, and then the case settled and it's ended. But because of that, we're allowed to refile the case against the Department of State, which we're going to do, and it's very likely going to be happening in the DC District Court instead of the District Court in Atlanta, where we filed initially, and did very well against DHS there. The DC District Court, there happened to be, there's litigation there, especially some recent litigation against the Department of State that is very relevant at the DC Circuit Court level to what we're arguing about. And we think that that we normally, the State Department is going to assert this concept called consular non-reviewability, basically saying that they're untouchable, that anything that they do with respect to issuing visas at consulates cannot be reviewed by a court. But that is not exactly true. Basically, an individual officer's decision can't be reviewed in terms of the applying the law to the facts in that particular case. But if you can demonstrate that there's a policy, or a statute or a regulation that is not being followed by the Department of State in adjudicating cases, you can do that. And you can also potentially sue them for decisions that are not being made by individual officers, decisions that are imposed on them from above, so that there's not you're not actually asking a judge to review a consular officer's decision. You're asking them to review the legality of a policy that is being pushed down to consular officers. So we're optimistic in the case. We are onboarding that case now for people that were in our plaintiffs in the first case. They are remaining with us, but we also are adding plaintiffs that were not in the initial case. And if you have had a visa revoked and you haven't litigated that issue against the Department of State, go over to I'll put it on the screen.
Yeah, that'd be perfect.
Go over to Impact Litigation's page. Here it is, and you can just take a screenshot. But you can go over there and see the frequently asked questions document that kind of explains the case, how to get into the case, and has the links to follow if you want to participate in that case. And we're hopeful that for the thousands and thousands of students who had their visas revoked, that we're going to be able to get a bunch of the decisions reversed on, at least for our plaintiffs, and hopefully more broadly.
Yeah, and I'll add to that, right, that this is, of course, this is related to those who had those revocations, right, related to the CVIS record terminations, right? So they're kind of all linked together. And the other thing that that's important in this case is that the student still has that revoked visa, right, should still be facially valid, right? So it should have a future expiration date, because that's basically the visa that we're trying to save here to get reinstated.
Yeah. I will sort of give a little preview of another issue because it factors into Aaron's question. That Adam, if you can see it regarding travel bans.
Yes.
But I mean, I'm getting a lot of questions from people who are saying it's like, who's going to sue? I'm a student from this particular country. I want to join one of these suits. And right now, there really are not any class or mass actions on travel bans yet. I'll tell you about one in a second that we are exploring. And if you are potentially think that this is something you might be interested in, you can let us know. But the travel bans are hard to litigate because of a Supreme Court decision from the first Trump administration, the Trump v. Hawaii decision, which doesn't give the president blanket authority to issue travel bans under any circumstances any way he wants, but it basically laid out a process that if the president follows, that he can essentially probably survive litigation on a travel ban. And basically, they have to he has to lay out the policy arguments and show that they've done, that they've tried to resolve the issue that was leading to it. So, in the first administration, it was all about security and saying that certain countries were not sharing information with the United States, that were, there were terrorist risks because of that lack of cooperation, and they basically did it country by country, and that's how they got away with it. This time it's a little bit more broad, and they're saying things like, this country has a high rate of people not complying with their non-immigrant visas. In the U.S. is an example of that, and that has sort of opened up one possible thing that we're thinking about. Folks that have followed me for a long time know that we did a lot of litigation in Trump version 1 on travel ban cases involving fiancés. And we did 6 mass actions for fiancés back in the first Trump term. Fiancés are covered in these travel bans because they are non-immigrant visas, and there are bans. I think it's in every country on K-1s that are coming in right now, but they don't ban spouses of U.S. citizens being petitioned. The main difference between those cases is the fiancés, the marriage is going to take place in the United States. The spouses of U.S. citizens, the marriage took place prior to the application starting, might have been possibly done in the person's home country. But there's really not a lot of difference between a fiancé of a U.S. citizen and a spouse of U.S. citizens. Usually it's it's just a question of the logistics of getting married that determine which one somebody is going to apply for. And there's not a good policy reason that we can think of why fiancés are covered in the travel bans, but spouses of U.S. citizens are not covered in the travel bans. And there's a certain arbitrariness to this. We think probably is the case is that they just lump them with non-immigrants because the fiancés are listed in the K category, even though it's sort of a quasi immigrant visa category. They do medical exams and extensive criminal background checks, and they have to show basically all the same kinds of things that they would show if they were applying for a green card as a spouse of a U.S. citizen. They have to show there. So we're thinking about that case. If you have a fiancé visa application for somebody from a travel ban country, and you just shoot a note over, and we're keeping a list to notify We're working on an FAQ now for that, and hopefully it'll be up in the next week or two on there. But that's the one travel ban case that we're looking at. Aaron asked a question about the in the several countries have they apparently have been given 60 days to comply with the DOS requests. I believe that 60 days passed. I think, and we were expecting to see more countries added to the travel ban. That hasn't happened yet, but that does kind of tie in, Adam, to this story about Ghana, which I believe was on that country list.
Right. And I kind of wonder if that's, the part with Ghana, with the visa crackdown, is that not connected to what we're seeing with the visa reciprocity limits that have?
But I thought that those limits are happening to countries that are on the proposed travel ban list. That's sort of like it's happening ahead of that, and I think there is some coordination that's happening to sort of like
that's
countries that are in that position.
I mean, I think most of them are, if not all. But yeah, I mean, we were seeing a lot of visas. I'm kind of looking at the list here, right now. A lot of visas that have gone. Maybe they were valid for a year and they've gone to about 3 months. So we're seeing that in a lot of different categories. B, F, J, M.
There was a really sort of, I know it's a local thing, but there was a really interesting story in the news here in Memphis about the University of Memphis. And there were 200 University of Memphis students from Ghana that apparently are not being, that they have not, they're having to leave because they're coming in on scholarship funds from the Ghanaian government, and then Ghana has basically stopped funding these students, so they have nobody paying for their tuition. And I just thought, and that story came within 24 hours of this other story relating to Ghana potentially being on the travel ban list. Ghana, these new visa restrictions that are happening over there. And I'm just like wondering if the Ghanaian government is basically saying, we're not spending good money. We're not sending good money after bad. If these students are going to we're going to pay all this money,
right.
And then these students are going to be banned from coming into the U.S. Why would we spend any money on that? And it's just like it's really sad for the students that are affected by it. But that was just sort of like how these kinds of policies end up playing out at the at an instant, at a sort of a local level. That affects community. 200 students is a lot of students for a city like ours that from one particular country. So that's unfortunate. All right, we need to keep it moving, Adam. What do we got next?
What do we have next? I think we'll move away from consular right now. Well, we have USCIS. I actually think that the commenter we have. Pooh Bear, not Yogi. Okay. If you want to put his comment up. How bad will things get under the new director? And so I'm wondering, I'm assuming that that's probably, just related to like USCIS director. And
he hasn't, we still have an interim guy. I don't think, do we have a confirmation yet? I don't think we have. I think we're still operating.
I remember the testimony, the hearing. Yeah.
But they're just doing what the White House is telling them to
do. Yeah. I mean, I'll just say, that we have seen, we're seeing some increased requests for evidence. We're seeing them in the H-1B context. As I was mentioned before, changes of status to TPS. Saw this kind of veering a little bit into student immigration issues, but it's relevant because optional practical training, there was some language that I saw on recent requests for evidence. I believe there are at least a handful of these, also nationwide, maybe more actually. But for OPT, there's a regulation that talks about the approval being of these applications, this type of EAD, being within the discretion of USCIS. And so if they see something like a dismissed charge, I think the one I'm looking at right now is a DWI, but it was like a dismissed charge, that they're still wanting to see arrest records. They're wanting to see all kinds of information about it, almost as if their discretion, is completely unfettered in the ability to issue EADs. So I want to put people on notice about that, because it's not just one. I know that there are more of these that are out there. So it's kind of concerning as sort of maybe a next possible point of attack. And Greg, you also had something about I-90s.
Yeah, the I-90s have been, first of all, I-90 is an application to you file if you've lost a green card or your green card's going to expire and you need it to, you're applying for an extension. And I saw this story that was a little, it was an alarming headline. It was like green card replacement wait time surge nearly 1,000%. Wait time surged nearly 1,000% according to USCIS data. And this came from, I think this was in a Newsweek story on there, but they reported that from January to March 2025, the median wait time went from a month to over 8 months. And that the application volumes and process and backlogs have surged. And this is an application that most people file electronically now.
Right.
So,
did it mention electronic versus mailing when it was for that?
I don't think so. But in any case, nobody's working on these cases. That seems like the obvious, the conclusion. The other thing was, I think once this problem hits, that it's at one point, I think they extended the amount of time that your automatic extension of your green card, you sort of have it, if you apply for this thing, you get a certain period of time that you're with the receipt for the I-90 that your green card remains valid. And they, I think suddenly decided they could take us, a lot more time on these things because the repercussions weren't as severe, since the person could prove that that their green card was still valid. In any case, it is this is all supposed to be fee driven, and raises the question of like, what are they doing with all this money? If people are paying this money for an I-90 and they seem like they've been able to get the fees wherever they at whatever level they want on there, there's really not a good excuse why they can't adjudicate these cases in a timely manner, especially applications now that are electronically filed. And these are not difficult applications for an adjudication in I-90. It's pretty much
like
ministerial.
Yeah.
So
these are expensive.
Yeah, we've seen this coming up over and over again, where the processing times are creeping up and up. Some of it might be political and ideological, where they are being deliberately held up. Some of them may just be because people are leaving. The USCIS has lost a bunch of employees and they're not replacing them. Some of them could be they are imposing new policies that are adding a lot of steps to the process before they can approve. We know that we expected requests for evidence to go up a lot. It happened in the first Trump administration. It's happened here. That affects processing time. So we're not expecting anything to get faster. The only way I think some things might get faster is it does seem like USCIS remains committed to their e-filing program and continued expansion of that program. And that's good news on there. That's they should be moving away from a paper-based program. With that, Adam, it was sort of like reminds me of the lunch discussion that we had today regarding the signatures on there. I don't know if you kind of want to explain that issue, but it sort of does make you think. It's like, why are we having this? Why is USCIS having this issue in 2025? Why are there handwritten signatures at all in any of these applications in 2025 on there. But why don't you explain kind of like what this issue is?
Yeah, I mean, basically the issue
to warn people about.
Yeah, I mean, the issue is that immigration, USCIS on mailed applications, that they don't accept e-signatures, and they want there to be a copy of a wet ink signature. Is basically what it is. So it kind of ends up being a situation where you have to like print out and sign something and scan it back in, right? So you have a copy of a wet ink signature. And it's very outdated, of course, as you're saying, Greg, especially since, they're allowing, any type of the authentication that they allow for online filings are pretty good. And we know that there's plenty of good ways to authenticate your e-signature, like DocuSign and things of that sort. So it's just odd that we are, having this sort of innovative online e-filing system and at the very same time, which, by the way, the e-filing, it works pretty well. I've used it for plenty of things like naturalizations, I-130s and things, but it's like you have that alongside this archaic mailed system where you have to have, copies of wet ink signatures. So that's kind of the issue that's turned into a request for evidence trend. So it's very important for individuals to make sure that they're signing it the right way.
Yeah, but it's not exactly a very tech forward agency if that's what they're hung up on right now, is whether they can whether they can validate that are these people that are adjudicating things handwriting experts? Honestly, right. It kind of reminds me of every time I go someplace and use my credit card, and you get one of those tablets on there, and you have to like sign your name with your finger on there, right. Like one finger on there, and all I do is a smiley face on there, and no one ever. And I've never had anybody actually ever say that's not.
And those would all be rejected by USCIS, right? So it's like that's kind of.
It seems like a smiley face would work if you could do if it was actually on blue ink.
Right.
Anyway,
right.
But it's all.
I did as we're. Right. As we're kind of talking about the delays, Greg, I think it's a kind of a good transition, to talk about. So, we talked about what's happening at embassies, right? You shorten visas, get 3 months instead of 1 year or several years, right? That just gums up the embassies, the consulates.
Means a lot more applications for the same number of people.
Yeah. And we're kind of talking about like increasing requests for evidence. What does that do to USCIS? There is also a rule out there that many of you may have heard about, right? A proposed rule that is with the Office of Management and Budget, I think, to analyze economic impact for the elimination of duration of status for I think it's for F and J, and there might be one other category, the media. Maybe the media category. Anyway, mostly F and J, right? So this was something that was also proposed in the first Trump administration.
Well, it was rolled out, but they did a policy memo, and I think our friend Jonathan Wasson, was the one who litigated that, and they had to back off on it because they didn't follow the Administrative Procedures Act, and basically issued a regulation level change without actually going through the steps that they need to go through. So my guess is this time they're probably trying to figure out how to do it by actual regulation.
Well, there was a couple of things that happened around the same time, so it's important to kind of unpack them, right? Because there was the duration of status limitation, but there was also this issue of unlawful presence accruing upon the violation of one's status, right?
Right.
Whereas typically that is triggered by a finding of an immigration officer, right? Or an immigration judge. That latter part is not part of this. Who knows, maybe one day, but not right now. What we're talking about right now is this, attempt to eliminate duration of status for F and J statuses, right?
Right.
And so
but once they do that, if they do that, Adam, then it basically the only reason that the 3 and 10-year bars don't typically kick in for F and J's is because of duration of status. You do away with that, and you've effectively done the same thing as what that previous policy was trying to do.
In a similar way, yeah. And I think that I can't really understand any good impact that comes from that. It just gums up everything. It will be heavily taxing on universities. It will be very taxing on USCIS to adjudicate all of these extensions. And it's kind of like, why? We have the SEVIS system. We have designated school officials and others. They have to be authorized, to be able to issue I-20s, to be able to access the SEVIS system. Like, they've already been authorized to do this. The students are the most monitored categories. Why
are they doing this? Because they are trying to end student immigration to the U.S., which is, the biggest economic own goal that probably I don't know, maybe basically kicking out all the people that provide the food that's on our grocery store shelves every day is similar to that. But, basically, if you want to kill Silicon Valley and you want to end innovation in the United States and end our economic lead, you do it by attacking the universities that basically, are the engine that drives all the innovation in this country. And and one of the ways to do that is to take away the foreign students that are in many cases keeping departments operating. They are important economically for schools because they pay full tuition to come in. They oftentimes are helping schools achieve international reputations because they have attract the best and the brightest students and scholars from around the world. And you may say, why do they want to do that? There is a lot there. It's become very apparent in the administration that there is a large contingent that do not, they feel like universities are sort of like elite liberal bastions, and they are trying to make them suffer on there, or trying to make them bend to the will of the administration's ideology. And they're trying to use student visa policies as one of the weapons in their arsenal.
Right, and that would be the unannounced reason. It's like, it'd be important to it's helpful to know like how they're intending to justify it.
Well, I mean, we haven't really seen. They've tried to make students sound shifty and untrustworthy by trying to make it sound like they were being removed for, that there are a bunch of criminals there in the U.S. or there are a bunch of radicals that are basically trying to disrupt education on there. I mean, if they can get the population essentially to believe that, it makes it a lot easier for them. But they haven't really presented any evidence on that they're any of the stuff that they're doing, that there's an actual need for it, or that there's been a particular problem with students, and that there's no data to back up anything as far as these policies that they're pushing.
And I will stress again to everyone that we have not seen any text yet for this new regulation, right? So it's like there was a proposed regulation, the first Trump administration, but that doesn't mean that language is going to be.
Did they actually issue a proposed rule?
There was a proposed regulation during the first Trump administration.
Well, the one thing about regulations is there's a process, and frequently regulations don't end up actually happening. And if they don't follow every single step in the process, or they ignore all the comments, then there will be litigation challenging whether the regulation was properly enacted. So that is, that we are expecting that. We saw that happen in the first administration. The public charge rule, for example, was a major regulation that came out that was going to make it much more difficult for people to qualify for immigrant visas and non-immigrant visas. It went through and got final regulations, and then it was challenged in the courts and stopped for there were a variety of legal arguments for it. So, Adam, when if it got that far where they were at the point of issuing a final regulation, that's one that could be challenged.
Right, right. I also wonder, I guess we have another question here. I wanted to mention, Greg, the only other items that I had were a few things that I think you had wanted to discuss related to immigration court and removal issues.
Yeah, I can just sort of say the headlines and
Sure,
what they are, and we don't have to really get into it. But one is that the Afghan TPS, a judge has basically stopped the administration for at least one more week of being able to start deportation proceedings for Afghan TPS recipients. So we said that we said there was only one good piece of news this week. That's another good one. ICE, there was I think a GAO report that came out in the last couple of days that said that ICE has arrested something like 450 Americans and that 70 U.S. citizens have actually been deported from the U.S. By ICE since the administration came in on there. So, we've seen a couple of anecdotal reports in the news about it, but it's not just one or two. I mean, 70 is a lot of people. The one thing that we also talked about this a little bit today at lunch, but there is this host of new, part of this big, beautiful bill. And I talked about it last week when I did that slide deck. There were a bunch of new fees that are being imposed by people seeking that are in immigration court. And those fees, they're things like $1,500 if you're requesting adjustment in immigration court. There's sort of like a $100 maintenance fee for asylum applicants. There's all these fees that are in there, but one of the challenges is that the EOIR just a couple of days ago, I think it was July 9th, issued an order to immigration judges in the local courts that people had to prove that they paid these fees now. And there's not actually a process to pay the fees. So that's created all this uncertainty now for people in immigration proceedings where it's like, okay, I'm not excited about paying this, but I'll pay it. How do I pay it? And it was like, well, we don't know how you pay it on there, but we're not proceeding with your case until you show us proof that you paid it. So that's typical. Another thing that was in the news this week that I think is sort of contradictory signs again is there were 17 immigration judges that have been fired in the last week or two. The immigration judges have a union. The union had reported it. It looks like they're purging judges that had anything, where they think they might have any leanings to being potentially not hostile to immigrants. One that was kind of interesting was one guy got fired, and it's believed that it was because in Chicago, Senator Dick Durbin had visited the immigration court, and the judge had offered to kind of give a tour and kind of like explain how things work at the immigration court. And that was enough to get the guy fired for being apparently partisan. So anyway, that's not good, but it's also, there's like 4 million cases that are pending in the immigration courts right now. And a very sizable number of the people that the administration wants to deport have to go through in front of an immigration judge under immigration laws. So firing judges is not how you make that docket go faster. And they're going to have to hire a lot more judges because of the increased number of people that are being put in immigration proceedings. And at this point, the numbers are shrinking, not increasing as far as the number of people that are there. And they didn't appropriate a lot of money in that big, beautiful bill to hire judges. I explained this last week that most of the money is going to ICE and CBP, but not actually to EOIR for purposes of hiring judges and being able to move more of these cases. So those were, those were some. The one that sort of like I've personally thought was the most interesting of the ones I sent you, Adam, beforehand was there was a story on FIFA, which is runs the runs the World Cup, and they're a pretty important organization. This was a headline that it was like eye opening. FIFA considers moving World Cup games from US to Canada on there. So a lot of people are sort of like already gearing up and excited about the World Cup being. It's in the right now. The matches are in U.S., Canada, and Mexico. But apparently, the new travel bans and the new immigration restrictions have gotten so many people complaining to FIFA from around the world that FIFA is considering basically moving the and even some countries that have qualified for the World Cup, like Iran, are banned on here. That FIFA is considering moving the U.S. Games to the U.S. Matches to Canada on there, which would be a complete humiliation for the administration. I've heard that the FIFA president has a good relationship with Trump, but so it was a little shocked to see this. But actually, there are consequences to this, and if FIFA does that, then you should probably expect to see the International Olympic Committee potentially look at doing the same thing for the Olympics, which are just 2 years later, still within the Trump administration for the 2028 Olympics in LA. So on that happy note, it's good if you're in Canada and you might get some extra World Cup matches on there, but it saddens me because I was really excited to. I'm still excited. I'm hoping that that somehow it'll be figured out. But that was the last story that I had on my list.
It's kind of like some of the universities that are sort of developing contingency plans, relationships with universities in Canada. Students aren't able to enter.
I mean, there are several universities that have campuses outside the United States now.
Right. Mm-hmm.
Even my college, Vanderbilt, has a campus in Palm Beach. I was like shocked. It's like, what are you doing in Palm Beach? But nowadays, I think it's not just you're not just limited to your home campus on there. So, all right, is that it?
I think we have one quick question, Greg, that was still there. Sure. Yeah. Changes to petitions.
Do we know of any changes of petitions for children over 21 parents to over 21 to parents with legal entry? So I think what this is talking about is U.S. citizen children applying for parents for green cards. There is nothing yet that's in the statute. So if Trump wanted to, they tried in the first administration to float an immigration plan. I don't know if you remember that, Adam, but this was one that had a point system, and it was going to move a lot of the family categories over to. Anyway, they had proposed eliminating siblings and proposed eliminating parents of U.S. citizens, and that didn't go anywhere. That would require a major compromise with the Democrats, I think, to have any chance of doing that.
That requires Congress to do something huge.
Yeah, and just so you know, the only this big beautiful immigration bill, a big beautiful budget bill that had immigration provisions. The only reason the immigration stuff that was in there could pass was it was strictly about funding, and there were a number of provisions that were stripped out by the parliamentarian in the Senate because they were deemed to deal with policy issues, which means that something like what was just mentioned in that comment would have to pass with a 60-vote majority, not a 50-vote majority. And they can't, everything that the Republicans can't get more than really 52 votes for anything. So they're not going to be able to touch immigration on a legislative level unless it is something that is very non-controversial, and somehow can pick up a bunch of Democratic votes. But that's one that would not be in that category.
Right. I mean, that's like built directly into
The
statute.
Lack and Riley bill at the beginning got that because it was sort of about crimes, and they were able to pick up some Democrats for that. But this is not in that category. Just regular family immigration stuff is not going to be touched unless they do some big compromise with something the Democrats want really badly. But I don't see them giving up on that one very easily. All right. Well, we're over time. So I think we will end there. Adam, I am going to be on an airplane next week, so I will not be here. And then I'm going to be on a bike journey. So I might not be here for the next 2 weeks. I hope people don't decide that they like it better without me. But I will. I don't know. Maybe we'll see if I can sort of squeeze it in between flights or whatever and pop in. But I will. I'll see people when I get back from travels. And thank you guys for watching every week.
Thanks, everyone.
Bye-bye.